We're now going to look at lines 825 through 827. We have a change in the language here for what is to be known as 5A, and you have that on your amendment 2250. If you see what we're doing here, the district attorney having jurisdiction where the local law enforcement agency or multi-jurisdictional task force is located shall be authorized to conduct the investigation, etc. We were looking at first to have the Attorney General's office do this, but in fact the local district attorney will have the best of information, oversight of that responsibility, and if he is or she is to be disqualified for any reason, you look at the insertion we're putting at line 840, 841, this is where the district attorney would make known the fact that they would be disqualified for whatever reason and refer this to the Attorney General's office for further investigation or prosecution. So the purpose of this is getting back to allowing the district attorneys to have the initial determination of whether there's been violations to bring the local law enforcement agency into compliance. If they find there has been some other wrongful conduct, they would take other actions for that purpose. But if they're disqualified, they would then look to the Attorney General's office of state to take up the proceedings. I move for acceptance of Amendment 2250.
Is there a second?
Second.
Motion and a second. Any discussion on the amendment?
I got a question, and it's more of a statement that I'm going to ask
That's called.
concerning disqualifications. And DA's here, certainly DA Porter can answer this for me. Doesn't most of the DA's offices have investigators, and aren't those investigators to an extent involved all the time or a great deal of the time with multi-jurisdictional task force?
I would say the answer to your question about most offices have at least one investigator per judicial circuit, because that's provided for by statute. Depending on the number of investigators, they may or may not be involved in a multi-jurisdictional task force. For instance, in my circuit, we have 2 multi-jurisdictional task forces, and I'm not involved in either one full-time as an investigator, so it's up to the individual DA.
If anyone is involved, then that DA is disqualified, huh?
I think potentially if the multi-jurisdictional task force was charged with some kind of malfeasance or misfeasance in the use of funds, the fact that a DA investigator was assigned full-time as an investigator would certainly argue in favor of disqualification.
The other day when we were down south and this came up, I started to speak up then, but I didn't. And, this is the last time I get that opportunity, and I was just concerned about that. And please don't misunderstand me. I'm not trying to bring the Attorney General in to be the prosecutor for the state. I was a DA. I didn't want him messing in my business either. But I was thinking the other day when this came up that it should be an either-or situation. If one doesn't, the other could, without having to be requested to do it. I'm not fussing at what's here. I'm just asking the question that I was of the opinion it should be left on either or of the district attorney or the attorney. The way we had it was Attorney General.
Yes.
Well, then the DAs want to be them. It's just my opinion. I was thinking it could be an either or, and I don't have heartburn either way with it. I'm just bringing it up because, particularly in the rules, most of their investigators work with most investigative teams, whether it's the burglary or homicide or certainly the jurisdictional task force, because that's the biggest agencies they got that going across their circuits. And so I think they would be disqualified, in my opinion, if they've got one up front.
Yes.
So all of them's ain't going to be requested, and I was just of the opinion we ought to make it an either-or situation. But
I can only respond to Representative Caldwell's concerns is that there is a statutory procedure that is frankly pretty simple in terms of getting the AG to assign another DA.
I don't have heartburn with it.
Yes, sir.
It's just a question.
I think your point is well taken in terms of the actual legality of it, And I think any DA with any sense would realize they were disqualified, and I think probably.
I've got a bill for y'all.
Maybe we have to have DAs with sense. That may be the answer. And we'll support that bill.
I understand.
But I think that the mechanism that's set up here allows for your concerns to be addressed without any confusion, because what I could see is a DA like me might say, well, I want to take it, and the AG might want to come in and say, I want to take it, and then we don't have any mechanism for solving that jurisdictional dispute, if it was an either or.
We had a motion and a second on the amendment. Is there any further discussion on the amendment? Hearing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries.